this morning from Richmond, British Columbia. They had a town hall meeting last night to discuss the Cowichan situation and the property situation. And his name is Ian, and Ian said, "Greetings, Shadow. I've compiled the following highlights from the City of Richmond Town Hall meeting about the recent court award to the Cowichan tribe of Aboriginal title to now disputed, privately held fee simple land in Richmond, British Columbia. At the City of Richmond Town Hall meeting, over 1,000 people, in my estimate, turned up. I was physically there, did a rough count. The mayor, council members, lawyers, the Attorney General of BC, and the official leader of the opposition in BC, John Rustad, was there, among many of the longtime Richmond families like mine who have resided in Richmond or had property there around 50 years or more, many for 3 or 4 generations. The meeting was about the recent court award to the Cowichan tribe of their claimed ancestral lands, which affects up to 150 properties that up until recently belonged to individuals, families, and businesses who purchased it legally over the past probably 100 years or so from the province of BC, i.e. the Crown. The following are key points from the meeting. 1, property owners weren't notified of the litigation against their property titles during the entire 11-year trial by anyone. Nobody knew. The Cowichan tribe, City of Richmond, province and federal government neglected their duty to notify property owners that their titles were under threat. Many of the residents only found out they had lost their titles this week from the City of Richmond letter they received about the town hall meeting and subsequent media coverage. Some residents have already been denied mortgage renewals and insurance for their properties. Bank won't renew their mortgages. The City of Richmond denies any responsibility or legal liability for their losses and directs concerned citizens to the Crown, i.e. province and federal government, to air their grievances. The City of Richmond did not offer a very good reason as to why they didn't notify the now former property owners of the legal proceedings against their property titles, except to say that it was up to the plaintiff, the Cowichan tribe, to do so. Many citizens expressed their anger at the mayor. Legally, it was the plaintiff who was responsible for notifying affected parties of the suit against their titles. The Cowichan tribe felt it had no obligation to notify the owners because they said the province are the ones who issued the fee simple titles to property they didn't legally possess or have the ability to sell. Oh my God. So those affected individuals held void titles, and the court ultimately agreed with their position, effectively stating that those people were just collateral damage for the province's error. We're not living in a serious country. The City of Richmond argued in court during the trial that property owners should be notified, but the judge denied their request. The justice presiding was allegedly appointed as a judge a few years before the trial without any prior legal background. There will be no refund on taxes paid or pause on taxes owing on the properties while the owners continue to occupy them or afterwards. Property owners report they are now unable to sell their land. Property owners express concern they have lost all the value in their properties. Residents are encouraged to lawyer up and attempt to gain intervener status in the case because they've been directly affected by this, you think? This is ridiculous. The City of Richmond is offering zero assistance, financial, legal, or otherwise, to affected residents, but would love to hear about their problems getting loans, insurance, or sales, as they feel this is useful evidence. The issue that some have raised, that Aboriginal title and fee simple title can coexist, is nonsense because they can both, by definition, give full and absolute rights of use, occupation, and control over the land. The Cowichan tribes have stated publicly in the news media that they are not after people's privately held property, but that is exactly what they stated they were after in court. A statement by the Cowichan tribe lawyer from the trial proceedings was paraphrased by the mayor and read aloud. The lawyer's statement from trial directly contradicts the public statements made by the Cowichan tribe to the media. The City of Richmond lawyers are arguing in their appeal that extinguishment applies, meaning that Section 23 and 25 of the BC Provincial Land Titles Act about fee simple title extinguishes all other claims to the land, including Aboriginal title. Interestingly, the province of British Columbia did not argue extinguishment, which the city lawyers feel causes harm to their claim. The Attorney General of BC did not offer a coherent or concise legal argument that they were putting forward in their appeal, except to say that BC needs a land title system that people can trust and rely on. We thought we had one. And that we need to work together on reconciliation. My God, her reasons sounded more like wishes than legal arguments. Keep in mind, she is an NDP member, right? The AG of BC is an NDP MLA. The Attorney General of BC ran away from the podium after her statement, and attempts to placate the crowd did not remain for questions. The Government of Canada argued extinguishment originally in their court filings and then removed it from their filings in 2018 without reason and never argued it again. The City of Richmond lawyers encourage all affected parties and concerned citizens to demand the governments argue extinguishment and ask them why they are not. The City of Richmond lawyers state that if they had not argued for extinguishment in the appeal, there was no other proper legal argument brought forward by the governments to appeal Justice Young's decision. They did it on purpose, it sounds like, because they knew what was about to happen, all this UNDRIP stuff. The Cowichan tribe also appealed the decision because they were not granted all the land they were seeking, only part of it, so the remaining lands in the claim were still under dispute, and as a result are affected by this ruling in ways mentioned above. Other tribes like Tawasin and Musqueam bands also claim the territory as their own, and they've appealed the decision as well. They can fight over it. It was stated there are over 200,000 Aboriginal land claims in Canada, and this case is precedent-setting, will be used in future litigation. Per John Rustad, BC's official leader of the opposition, 108% of British Columbia, or so I guess he meant to say 100% of BC is claimed by Aboriginals as their own. According to the City of Richmond lawyers, the consequences of this Aboriginal title award are far-reaching. They state this ruling unravels the fee simple title system and completely undermines it, which could effectively nullify everyone's titles to their land as this winds its way through the courts. The city lawyers state this could take upwards of 5 years to wind through the system, maybe longer. After the meeting, I brought up with one of the city lawyers that Justice Young had referenced that Canada and BC had legislated UNDRIP and DRIPA into law in her ruling, and the city should be demanding the government's repeal UNDRIP and DRIPA right away because it negatively affects their arguments for extinguishment under Section 23 and 25 of the BC Provincial Land Titles Act. The lawyer did not seem to want to discuss this and looked physically uncomfortable when I brought it up. I pointed out to the lawyer that UNDRIP and DRIPA effectively nullify his argument and usurp the BC Land Titles Act because Aboriginal title is now considered senior to fee simple title. Ian says, it's my opinion that the city lawyers are completely aware of UNDRIP and DRIPA, undermining their arguments, and that's why they neglected to bring up the pair of legislations, federal and BC, at Town Hall. UNDRIP and DRIPA were the giant elephant in the room that nobody could see. They were not mentioned at all in the main town hall meeting, and unfortunately I was unable to bring it up because only those on the immediate direct affected properties list were invited to speak. It's my opinion the city, province, and federal appeals will be thrown out unless UNDRIP and DRIPA are repealed. The City of Richmond said they now have an informational page on their website dedicated to this issue. For more information, sincerely, Ian Furstrom. Thank you very much, Ian, for that detailed email that you sent me this morning. Here is the mayor